Welcome back. Welcome back, everybody, and thank you for joining us today. For those that are just joining us, we had an excellent, tremendous morning panel focusing on the role of racialized surveillance in society and immigrant surveillance, and this panel promises to be just as dynamic and informative. Before introducing the amazing group of panelists here today, just a programming note that if you have a question for our panelists, we'll start off with a discussion among the panelists, but there'll be plenty of time for audience Q&A. Please avail yourself of the Q&A function in Zoom, not the chat function, and that way the questions will get to me and I'll be able to ask them and give life to your insightful inquiries. And with that, it's a real honor for me to introduce this panel on categories of control, the regulation of sexuality in gender. The panel includes some of my personal heroes. Some of them are not only brilliant and incredible activists, but also amazing ice skaters. I've been able to see them on the ice. It's really amazing. Needless to say, when this occurred, I was too chicken to participate. I'll respect everybody's privacy and not identify who I'm talking about. So with that, we are joined by, I'll keep the introductions brief because their full bios are available, but Dr. Alex Hanna is a senior research scientist at Google. Dr. Anna Lauren Hoffmann is an assistant professor at the University of Washington Information School. Avatara Smith-Carrington is the Tyrone Garner Memorial Law Fellow at Lambda Legal, and Gabriel Arkles is senior counsel at the Transgender Legal Defense and Education Fund Till Death. Avatara, I'm going to let you get us started here. And thank you so much for joining us and all your important work on behalf of queer communities, in particular queer communities of color. Queer people, as you know, and particularly queer people of color, live their lives in webs of administrative and carceral surveillance. And before we dive deeper into a broader discussion of how to potentially subvert that surveillance, subvert those webs, either practically or legally, I was hoping you might start us off and help situate our conversation, particularly with regard to the audience, by describing some of the ways that queer people's lives are monitored and shaped by different surveillance regimes.
Cool, no problem. So really excited to be here. Avatara Smith-Carrington, they, them pronouns. And I'm sorry if there's a ping in the background. Yeah, I've been thinking about, how I've seen, queer and trans folks moving in spaces recently, whether they be physical or digital, and like what it looks like to actually talk about this in relationship to privacy. Because, the running joke amongst some of my friends and I, especially folks who are also like Black, queer, and trans, and then also holding other identities, is like, what does privacy actually look like to us when you're in a space of both like being visible in some ways and hyper visible in some ways, but then also invisible. And so like I was having a conversation with a friend recently about specifically identity documents. And we were just talking about, what it looks like to start talking more about an X marker, but what that means for specific people. So like specifically for Black and brown people who are trans, non-binary, and choosing to have an X marker. And one of my friends said to me something along the lines of like, well, that's an interesting thing for me because I feel like, with regard to a conversation around privacy, I don't actually know what that looks like because in many ways, my privacy is already denied at that point. like in many ways, there's already a conversation happening around my body, specifically in relationship to race or in relationship to talking about, perceived immigration status or, all these other things. And what does that mean in this grand scheme of things? So, as I've been thinking about like, what does this mean and how is it showing up and like also what's happening in these different areas, I've been thinking about like all these different states and how like you're seeing legislatures like, legislators move to infringe upon the privacy of like trans folks, right? So you're seeing like these pushes in the realm of sports and healthcare to talk about things like sex testing, which I mean, like at the end of the day, like what are you actually discussing? And also when are we going to be real about like what are you implying and like who are you deciding to police? Because in many ways we talk about it in the sense of like, thinking about gender, but like also you have to start thinking about race, right? And thinking about how race is also playing into who's actually going to be more likely to be policed in that space when we're thinking about sex testing and whatever that is. And then also, again, moving into some of like digital spaces, the one thing that I've also like always thought about is like how a lot of queer and trans folks, a lot of Black and brown queer and trans folks have created homes, have created spaces to organize, have found themselves through like these digital communities, right? And so when we've talked about privacy, I've also like thought about how like in many ways, a lot of us have been like kind of like the miner's canary in a way, because we've been able to flag when there are actually issues around like what we're thinking about with privacy. Like we're able to tell folks like, hey, like the way that Instagram is showing up and how certain bodies are being policed or how certain things are happening for certain communities, but not others. And like, why is it happening more for this community than other communities? And so like, again, there's been like this really interesting thing, at least for me, in the ways that I've been seeing things unfold in both physical and digital spaces. Of course, they often overlap. And, again, I kind of come back to, and I hope that this is making as much sense as I wanted it to make, but I kind of come back to, like for who does privacy actually exist? What does it look like when we're talking about subverting these things? Because I feel like some of us naturally subvert these things because, our personhood is almost an antithesis to everything that we talk about. So when I think about like, specifically Black queer trans folks and gender, I'm just like, well, for many of us, we're going to be bred in a certain way. And a lot of our boundaries are already going to be pushed in certain ways because that's just the history of how things have unfolded. So yeah, it's been really interesting to think about, especially right now, especially with the way that we've seen a major uptick with regards to the states and like their pushes to like, attempt to erase trans folks and attempt to like criminalize and punish trans folks for just existing. So yeah, I'll just stop there for now.
No, thank you so much, Avatara. That was fantastic, and I think that that tension between visibility and privacy for trans folk, for queer folk, for in particular queer BIPOC folk is a topic that I hope we'll continue to explore. I want to give the other panelists just to jump in to build off Avatara's comments if they like to. Go ahead, Gabriel.
I mean, so Avatara, it's interesting with the ID cases, because we do often bring privacy claims in those cases, right? So we'll argue that when the state forces me to have an ID that says F on it, then that means, I'm not just being misgendered anytime I use it, but I'm also being outed as trans anytime I use it, because they look at my ID and they look at me and they draw a certain conclusion. And our opposing counsel will make arguments like, oh, but aren't you proud to be trans? Aren't you actually out as trans to some people? And so then we're put in a position of trying to argue, well, yeah, it's not about whether I'm proud of being trans, it's about whether if I'm pulled over on the road, do I want the police officer in that moment to see that I'm trans in this particular way? Like, is that going to be safe? And different people in our communities have very different answers. Like, Black trans people are much more likely to experience violence in those situations than I would as a white trans person. But then it's also, but then that and even those privacy arguments have their limitations, right? Because if we are going to be pushing for people to get access to a gender that lists something other than M or F, then the outing argument doesn't work quite as well, right? Because if you see an X and people assume that you're non-binary, then we're not sort of arguing for something that makes you more visible, right? As opposed to something that makes you less visible, um, which 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 makes things more complicated for that particular legal argument. It's one of those limitations there.
Yeah, and just to build off that, Gabriel, I mean, I think definitely privacy, as you know better than I, in your amazing work advocating and fighting for trans people in the courts, has been an important legal tool, as you just underscored. But like so many legal tools, it's also really limited, and we've seen this debate and this tension sort of recur throughout many social movements, many social legal movements, right? Like what are the trade-offs between fighting for short-term inclusion or inclusion on the master's terms versus long-term broader emancipation, right? And so a lot of queer legal activists have fought for better access to stripping down the requirements to get to get an M or an F on an ID document, right? But the box is still limiting. It's still controlling. And do you think we just have to embrace the fact that we're in some ways enshrining the boxes to a certain degree, and that does have limitations, or should we move away from advocating for greater access and freedom to the boxes and advocating for dismantling categories altogether? And I'll start that with Gabriel, but very much interested in everyone's perspectives.
Well, yeah, that's an interesting question, and it's one, of course, that's been debated in a lot of spaces for a lot of time. Um, I mean, I initially, before I graduated law school and started working with a lot of different trans people, just from my own experience, I was like, we should take sex off ID. There's no reason to have sex on ID. It just causes problems for so many different people. But then actually, when I started working with um, a lot of low-income Latina trans women, one of the things that struck me was that a lot of them were asking if we would at least issue them some ID that listed them as female, because in some of the different like violent single sex spaces that they had to navigate, like having anything that acknowledged who they were sometimes made it easier and safer for them to just get through those spaces. Like anything, whether it's a public restroom or whether it's a homeless shelter or whether it's like a welfare office where you have to use the bathroom, right? It's just and and so that really shifted my thinking that for some people having ID that lists your gender accurately can be a tool for self-advocacy and can be a tool for survival. Um, and made me think it's actually probably unwise to totally take it away. What I what personally where I am at the moment, and I continue to shift my thinking on this over time, and I'm interested to hear what other people think, um, is that I think sex should be an optional field. I think people should be able to say, I want sex listed on my ID or not. And if it is going to be listed, I should be able to say how it's going to be listed. Um, but I don't know. I don't know if that's actually the best answer, but that's kind of the best answer I have at the moment.
Other perspectives on this particular question?
Hi. Yeah. Hi. Thanks for convening us, Scott, and thanks Avatara and Gabriel for getting the conversation started on this inclusion point. And the kind of dichotomy that gets set up between this kind of a particular kind of like wholesale refusal and versus a kind of negotiation within the system. I often find it a little often untractable, like intractable as a question. And instead, I like to think about like, well, what is the work that inclusion, that the idea and the term of inclusion is doing at a given moment? Like, how is it structuring relationships between differently situated individuals? And when I say differently situated, I mean like hierarchically according to relations of power and so on. And outside of the ID example, I've thought about this a bit in the context of the design of online platforms, and I know that the digital privacy was a big theme in the previous panel. And I think in particular about there was sort of some recent-ish in the last few years developments for the on the dating app Tinder. This is an example I like to go to, but for folks that don't know, you know, Tinder is a dating app or a hookup app, and it's primarily structured around sort of your kind of like gut reaction to images, and you swipe one way if you find somebody's profile picture desirable, and you swipe the other way if not. And what sort of Tinder learned over the course of sort of its first handful of years of existence, first few years of existence, was that this was causing some, this was resulting in some harm to in particular folks with some non-normative gender presentations, and so you had an instance where a trans woman, a straight trans woman, would be on the site, would go in and identify by binary categories that they were offered. I'm a woman, I'm looking to date men, and then there would be cisgender men who would be scrolling through and they would see a woman that to them they were like, oh, this isn't a real, quote unquote, real woman, or they that kind of toxic and harmful stereotype, and then they would report these profiles as fraudulent. Like they wouldn't just like skip past, they would like literally report them as like, this is not a real woman. And then initially Tinder got in trouble because the process of like dealing with sort of claims of fraud was automated. And so, after a certain number of claims, you got a warning email, and then after a certain number of claims, you got banned, you got locked out of the site. So there was these trans women that were being locked out of their accounts. Because they were the automated process was agreeing with the assessment, whether or not on purpose, right? Was agreeing with the assessment by these cis straight men that these women were fraudulent. And so eventually they expanded a set of categories that people could use to identify themselves and also to indicate who they were interested in dating and who they were interested in having see their profile. So this is a kind of a privacy intervention, right? Like it allowed people to sort of mediate their visibility on the site and filter their engagements on the site in particular ways. And this was like really largely met as like a sort of boon for inclusion. It was sort of universally celebrated by queer orgs and celebrities and some activists. And I don't want to deny the fact that like in the sort of like day-to-day interaction with the site, that's going to like reduce harm. I don't want to deny that. But there's a broader scheme here where this move to inclusion, by sort of designing the site in this way, kind of offloads the work of visibility, of managing one's visibility. It offloads it onto the sort of the affected parties. And then on the platform side, you reap a set of benefits, whether they're economic, because more fine-grained data on your users can be useful for targeting particular things or can be useful for resale. Political benefits, insofar as like you can show that, look, we're doing this, you don't need to regulate us, or you get third-party organizations who watchdog orgs who might otherwise be your critics to celebrate you, right? There's a set of social benefits that come with that, and political benefits, and then like awards and good press and accolades. So there's like this tremendous set of benefits that accrues because of this inclusion move. And then there's a set of kind of like not insignificant, but certainly not monetarily or otherwise like significant benefits that accrue to the people who are harmed in the first place. And as Avatara pointed out already, it's usually the same parties that are having to like come to platforms and say like, this design is harming us, right? Like we're the ones like constantly raising the issue, and then we're given new tools while all of these other benefits accrue. So this is what I think about in the context of inclusion, is like how is it structuring or restructuring relationships, and who's carrying the burden of sort of like raising the issue of inclusion, and then who is reaping the sort of broader economic and political benefits of those moves towards inclusion. And I find that to be that's the lens that I often pick up, rather than thinking in this dichotomous sense of like, do we refuse, do we navigate within the system?
I think that's really helpful, Anna. And I think that I think that sort of approach to it could have value in the law reform context, because I do think, you know, and I don't mean to set up a false dichotomy, but I do think that law reform advocates often think in some of those terms, right? You know, like what are the short-term benefits? Like, are there harm reduction benefits? You know, yes, we should try to capture those. And I think privacy scholarship more generally, you know, needs to think more about harm reduction, but you know, also trying to at least keep one eye on what's being and who is being excluded. But you're absolutely right that I love that frame, thinking about you know, burdens of inclusion as opposed to, you know, sort of an on and off switch. I find that really helpful. So thank you. Any reactions to Anna's powerful example?
Yeah, I mean, I'd love to jump in. And again, thank you so much, Scott, and Gabriel, and Avatara, and Anna. I'm so happy to be in dialogue with y'all. Yeah, I mean, building a bit on what Anna's saying, and, you know, thinking about what the kind of dynamics of inclusion are. I mean, I think, you know, pulling it back and I mean, less in the law reform frame, more in the sort of design of socio-technical systems frame, is kind of thinking about, you know, what we lose when we're included, or what's at stake when we kind of give into it, into kind of modes of inclusion. And so, for instance, you know, a lot of my work more recently has been looking at computer vision technologies, and you know, in computer vision technologies, this is stuff that includes facial recognition, but it's also stuff like facial analysis, facial classification, gender classification. And I mean, this has ramifications for a lot of different spheres. It's not only facial recognition kind of gets the most play, but because it's very visible, it has very direct ties to law enforcement and policing. But there's also kind of these other areas in which things are deployed in different ways. So for instance, gender classification in technology, for instance, can be deployed in kind of multiple different domains. You could think of, you know, situations in which I think this might have been deployed in maybe one of the Emirate states, one of the Gulf Arab states, where you know, there are sex segregated facilities and things like train cars or washrooms. And you know, there's talk there of deploying some of these things and restricting individual entry into places based on some kind of automated gender recognition or automated gender classification. And this is very much relevant to the sort of kind of applications that Avatara is talking about when you're thinking about state level laws around restrooms and access to sport. And so these technologies are sort of, you know, tested and evaluated in various different ways, either from commercial AI that does kind of gender classification, or some kind of also these data sets through which these evaluations are done. And so one of my collaborators, for instance, Morgan Klaus Schauerman, who was an intern with me last year, has done some amazing work around evaluating some some systems that do gender classification, and has shown gender classification systems, commercial gender classification systems, perform much more poorly on trans folks. They are sort of nonsensical for non-binary folks. And he's gone through and also looked at these evaluation data sets, which look at do some kind of gender or racial classification and find how they define these things. And so there's kind of a mode of inclusion that kind of gets deployed here. So some folks in the kind of computer science or AI domain looked at this work and said, oh, you know what we actually need is that we actually need like a non-binary gender classifier. And you're like, no, that's not what we want. Like, this is not like, because, you know, if you're going to build a non-binary, you know, a trinary gender classifier, what it's going to end up doing is you're going to have male, female, and non-binary. And, you know, first, it's nonsensical to even talk about non-binary gender classification, much more so than doing so for male and female. And also, who do you think, you know, the archetypical non-binary person is probably going to be like a white assigned female at birth person. And so like this is going to like perpetuate a particular sort of like notion of what like a non-binary person looks like, that and really entrench that, things that we've already seen in other socio-technical systems of entrenching, you know, who's an engineer, who's a homemaker, all these other things. And so, you know, like I really appreciate thinking about and deconstructing this idea of inclusion and thinking about like, well, is inclusion the right frame? You know, like what does this actually mean, and what are ways of kind of resisting and thoughts on that. So from there, I sort of, you know, I sort of have been playing with two concepts lately, and the first one is thinking about kind of resistance and sort of a way of thinking about, well, not only understanding, you know, being transparent about how these decisions are made, but also finding ways to challenge them and contest them and that work for particular types of people. And so one concept that some collaborators and I have sort of been thinking through is the idea of contestation, especially contestation in design, especially socio-technical systems. This is an idea that sort of draws on somewhere from Deirdre Mulligan and Ted Hurst, that kind of goes beyond thinking just about contesting, being transparent or thinking about things being accountable, but rather thinking about, you know, what engagement looks like, what does it mean for a predictive algorithm, how is it actually going to support people, you know, and in some way it's getting past, you know, like let's crack open this black box and sort of see what's inside of it. But this concept also has kind of important limits, also because it sort of makes the onus of making things contestable sort of in the realm of like the designer. Um, and and I find that limiting, because I sort of critiques of design have been made from Lily Irani and Ruha Benjamin, who have called design, frankly, colonizing, frankly, very Western in nature, being posed to other modes of thinking. And so, you know, something I've sort of thought about more lately is this idea of more of complaint. And this is coming more from Sarah Ahmed's work on complaint. And the idea of thinking about what complaint does in thinking through different organizational arrangements. And so, you know, she said, to complain within an organization often brings you up against it. In making the complaint, one has to teach themselves about how the university, in this sense, she's talking about university complaints, but how the organization works, and how it's failed its own policies and procedures in relation to quality and dignity. And so I really think that's helpful. And kind of the sociologist in me kind of reaches back and says, okay, what's the work of complaint? What's the work of reaction? And, you know, you have to learn a whole different language to make a complaint, right? Of an organization. You know, there's a lot of fuck shit happening at Google right now. I'm learning a lot about the organization of Google in understanding, how to properly lodge a complaint, right? And so, and I think that's sort of a helpful analytic, I think, especially for folks who are challenging these organizations and these systems which perpetuate violence.
So that was super rich, Alex. Thank you, and a lot in there. I might just to it's interesting. I mean, we have people here from different sort of disciplines and professional backgrounds, and I think that provides us some opportunities. And one thing, Gabriel and Avatara, maybe I'd love to get your reactions to what Anna and Alex were saying. In particular, two themes. One is, and this Anna didn't mention this term, but part of her scholarship focuses on this concept of data violence, and that these systems are doing real harm to queer people, and she described those harms without using that term. And I guess from the perspective of a legal services provider, right? Where your clients may be concerned about data violence, but are also concerned about like physical violence. Like, do you find that this that framing is helpful or creates a false equivalency? And relatedly, like, it's interesting hearing Alex talk about complaints. Gabriel, like in the prison context, as like the PLRA, like there's procedures for filing proper complaints, and those procedures are where complaints go to die. And so I'm wondering if your experience with complaints in a more embodied context might provide some insight to what Alex is thinking about.
Should I start? Okay. So well, I mean, so I think all of these things are related, and sometimes maybe even talking about the same thing. I mean, one of the first things that comes to mind when I think about privacy and trans people and legal rights is just I mean, over the course of history in European and US law, there have been these quote unquote gender checks, which are really genital checks, strip searches of trans people to see what we have between our legs. And I mean, you can see examples of these being ordered by various tribunals in 1500 Spain and 1600s Virginia. And you can also see news stories from this year, from 2021, about trans people subjected to strip searches just for the purposes of seeing what's between their legs in various in contexts where people are dealing with police or when they're in jail. And the courts give a lot of deference to law enforcement and prisons to do a lot of things in terms of searches. Even so, in general, the premise is that they're supposed to be looking for contraband or something, right? Not just literally looking for somebody's genitals. But that said, while there's been some litigation on it with some decent settlements, I mean, there's not really a lot of good case law on this so far. And it just keeps happening, even though we have gotten some policies put in place saying that these things shouldn't happen. It's in the Prison Rape Elimination Act regulations, these things shouldn't happen. They continue to happen. And also, I mean, still in the sort of criminal context, there's a case several years ago in New York where a homeless trans woman was on the street looking at a purse. Police searched her. They found that the purse was stolen and charged her, and she tried to get that evidence suppressed because there was no legal basis for the search. And the trial court said, sure, that's right, trans people exist. Seeing a trans woman on the street looking in a purse is not probable cause. But the appellate court said, no, look at the mugshot. This person had some visible stubble. Seeing a man look in a purse is probable cause for a search, because men do not carry purses unless they've just stolen them, right? So privacy law in those contexts should be protecting trans people, but it really isn't, or at least not in reality or not consistently enough. Um, and uh, and I and so I mean, and then there's this whole other level of surveillance where law enforcement is using facial recognition, including gender categorization, to try to apprehend more people, or reading people's social media profiles to try to find evidence of crimes. Um, and I sometimes, as a lawyer, have been in a position of wanting to get more data about how trans people are treated in criminal legal systems. Like I want to be able to see what's happening to be able to better build a case, because sometimes we have people saying, well, there just aren't enough trans people to even worry about, or, oh, the things that you're saying happen in prisons, jails don't really happen. So sometimes I want that data, but every time that I have, almost every time, this, I'm not universalizing too much, but almost every time when I've spoken to an organization that is led by trans people of color who have been criminalized or incarcerated, they're like, you want what? You want to tell the cops to ask us what? No, thank you. Like, in what world do you think it would be safe for us to get asked whether we're trans when we've just been arrested, right? So I think the questions um, that Alex was raising about, what does inclusion do is really important in this context. Like, like there may be some benefits, but there are also some really significant harms. And even if I think it would be nice to get the data, I feel like if it comes down to it, that a person's going to be in more danger in the moment that the data is collected, then I don't want us to do it. I mean, that analysis is going to be context to context. But in this context, I think the less data law enforcement has, probably the better.
No, I mean, I was just going to go off of that, Gabriel, when you're speaking, because I was just thinking about it. I think that so often, the response of folks to state violence is like, well, the more data we collect, the better able we are in terms of like approaching or navigating how to address this problem. And I agree in many ways. I just, and again, it comes back to like exactly the conversation that's unfolding here is like, but at what cost? Because you have to recognize that at that point, especially in these specific contexts, you're putting people in closer proximity to violence, because in a way, naming who you are in that moment allows for people to then decide how they want to treat you, whether it's based off of their first perception or now having additional information. And then again, like, what does it then look like to also have those points, like those data points follow you into different systems? Because I think that when we talk about it, coming back to the driver's license is like, for me personally, because I know that like I will never be gendered correctly in an interaction with most people. It's like, okay, so like I could for myself like opt into having an X, but that also invites further conversation. And then what does it look like to have that marker follow me in different places? Because in some spaces I actually might be in closer proximity to safety. In some spaces I might actually be guaranteed a little bit more privacy. In other spaces I'm actually like opening myself up to an onslaught of violence that I'm just like, I actually would rather not. Like, I actually would like to opt out. And so, kind of, coming back to that point, I think it's like really interesting when we talk about that, especially in the context of privacy, because again, I guess like I always come back to like, what does privacy look like to who, and like, why does it look like that? And like, in what ways can we talk about, again, how certain people are already kind of like pushing the boundaries where they will never be actually, they will never be able to claim privacy in the way that most people think of it colloquially. So yeah.
That's super helpful. And I think both of those examples that you both provided in some ways underscore Anna's point, which is like the burdens of inclusion are falling on the people whom inclusion is purportedly designed to benefit. So that really, I think that resonates really well with Anna's point. Any other thoughts on this topic before we pivot a little bit? I do think, and this next question, I'll start with Alex, and I think we've Avatara in particular touched on this, but there's a tension, right, between ensuring access to digital networks, which are key to queer communities and queer identity formation, right? But those same contexts, and Anna's Tinder example underscores this too, become where mediums of connection can become weaponized, right, to harm sexual and gender minorities. And so, Alex, in particular, given your position at working for a benevolent master, how could we take measures, or you talked a little bit about contestation within the industry itself, but I'm wondering if you have thoughts on how we as individuals can take measures to resist having our networked lives be rendered by Google and other tech capitalists.
Right. I mean, yeah. I mean, this is a pressing question, and I mean, I guess my initial sort of thoughts on this are thinking about the kind of, I mean, different modes of kind of identification and datafication. And I mean, I'm kind of curious, like, it's interesting that Anna brings up the Tinder example, because thinking about sort of different kinds of architectures of, that are sort of anti-data collection in some kinds of ways. I'm actually thinking about, there was this social, it's since become like a social network, but there was like an Instagram account called Lex for a certain amount of time, which was, like basically, and it was sort of anti-classification in nature. And so in some senses, it was like, you would post some kind of ad, and it was kind of like an old school personal, and you would just write the text, and you really didn't have to identify at all. Like you could write whatever you wanted in the ad, and there was no kind of architecture of kind of data collection. And I mean, there's other problems with that platform, which we don't have to go into now, but it was kind of an interesting kind of mode in which, this kind of self-identification, and disclosure as one wanted to present in a sort of, I want to say libidinal economy, but I also don't know what that means. So like but in sort of, these kind of network of desire, basically kind of like and sort of this way of kind of pushing back against that. And I mean, and the more and more, you sort of do these histories of kind of the early trans internet and early queer, networks, this sort of, there's this tendency to push back much more against these sort of ways of organizing and identification, both for safety reasons, but also for sort of like knowing that the kind of identities are queer and fluid and whatnot. And so, there's folks who have done a lot of great work on that. Kate McKinney is someone that comes to mind, who's done some great work on that. And then the question becomes like, well, how do you sort of change the arrangement when it comes to these networks like Google, like YouTube, like Facebook, and the kind of flip side of Anna's example on Facebook is that, Facebook was heralded, a couple of years ago when they added, I think, something like 51 gender categories. But at the end of the day, it actually reduced to like male or female. And, basically because, Facebook's an ad network, they need to market to male and female, like that's what the, in the world in which you can hyper specify identity, you know, male and female are still useful advertiser networks. The same thing happened with Google, I think a few months ago, when it was revealed that they added a non-binary category, but then that was actually excluding people from certain advertising networks. And so like in some sense, that kind of exposure could be seen as like a kind of a backwards like win. Like you're not actually advertised to, so you're actually in some ways, by virtue of being non-binary, kind of opting out, but it is, you know, what kind of benefits are you losing out and not being legible to a system like that? And so, you know, what does it actually mean in this, and there's other examples in which being identified as trans or gender nonconforming is, you know, in some senses advantageous. So one case on digital networks where this has very, very deep monetary effects is YouTube monetization. So YouTube encountered, I think, a lot of criticisms because some YouTubers, trans YouTubers, were doing things like, you know, they were posting their, you know, their transitions on YouTube, and they would, you know, and they put the word trans or LGBTQ in the title, and YouTube was actually demonetizing that, you know, and YouTube actually has very little idea of how to actually present that content to children, and will sometimes exclude that content in children. And so, you know, on one level, you know, actually identifying as being trans is, you know, advantageous for, let's say, benevolent, you know, benevolent overlords, including my employer, that would be actually wants to try to combat that, but at the same time, you know, putting oneself out as trans on the internet is, you know, surely, you know, becomes a very quickly a vector of abuse and harassment and in this kind of, you know, what I think Avatara put very well, you know, this kind of dichotomy of being both hyper visible and invisible at the same time. And so, you know, these are real questions. And I mean, there's not really easy answers, but, you know, we're seeing so many instances in which trans and gender nonconforming folks are just falling through the cracks in these systems.
I think that the Facebook example is super powerful to me, and it illustrates, I think, you know, part of Anna's critique of inclusion efforts or narratives, because it's like, even if you even if the public facing, you know, options are broad, right, and, you know, they're trying to appear inclusive, what's being done on the back end? You know, are those identities being aggregated? Okay, so that, you know, the people are being classified in ways they don't want to anyway for advertising purposes, or, you know, just as harmful potentially, being excluded. And one thing I've been thinking about just a little bit, actually, and mostly in the context of being a recent member of the committee that puts on the Privacy Law Scholars Conference, is we, you know, it has traditionally not been a very, it's been a very homogenous community. And so in an effort to think about holding ourselves accountable to changing that, and changing the culture going forward, one topic that's come up is like, okay, well, how do we measure over time, okay, without just like, you know, sort of gut reactions like, oh, we are now more diverse. Like hold the program committee accountable over time for making a more inclusive environment, or welcoming environment. And so, you know, it's like, okay, well, should we start gathering data on who comes? And then, you know, the question is like, well, then what questions do we ask? And then it's like, well, if we ask really broad questions, okay, you know, basically allowing people to provide information that they think is relevant, does that actually allow us to track over time? And I think that requires thinking critically about how we present data, right? Like, it doesn't need to be some bar graphs, right? Like it could be a word map or word clusters or something, that captures the richness of a community, rather than trying to squeeze people into boxes on the back end. And obviously that's easier to do with small data sets like a conference, right? You're dealing with a couple hundred people, but I wonder if thinking about data presentation and data arrangement on the back end in more creative ways may, particularly visual ways of displaying data, might provide some avoid some of the back end problems that are illustrated by your Facebook example, Alex. I don't know if you have a reaction to that at all, or anybody.
Yeah, I'll build on that too. I just want to note though, like one of the things that this conversation can a path that it can lead us down, or a kind of discursive construction it can trap us in, is this idea that like there are going to be like sort of good technologies or bad technologies, that we're going to have these buckets of like good, this is a quote unquote good data practice, this is a quote unquote bad data practice, this is a good privacy policy, this is a bad one, and we're gonna fall into this like this like binaristic moralizing trap that we fall into with inclusion as well. And I always come back to this, but it instead of sort of sorting these efforts or initiatives or boxes, or even more sort of simplistic technologies like gender categories on a identity document, right? That's a technology. An identity document is a technology. Is to think about, again, like what kind of relationships do they organize? I was just reading the introduction to Max Leboiron's new book, Pollution is Colonialism. It was just released, and they have a joke in the intro about paperwork being, how could paperwork ever be liberatory, right? As like a technology, like how paperwork is colonization. Paperwork is colonization. It's oppressive. Why do we have to do paperwork? And they point out that there are examples of paperwork required by, say, indigenous research ethics boards that actually serve to slow down and interrupt the function or the operation of sort of settler colonial scientific practices, going into particular communities, extracting data, or using particular lands to conduct research, right? And how then paperwork and ticking boxes and these things can then become a tool to sort of slow down the operation of power in that way, of oppressive forces in that way. And I just like, I want to like kind of come back to is like what relationships does something like a gender category codified, whether it's on a platform or on an identity document, what relationships is it structuring? And who is vulnerable in those instances, and how could it be otherwise? And that to me is rather than kind of slipping into these like, well, this would be a good practice, this would be the bad practice. Well, no, these are tools, and we can use them to slow down those who would do us harm.
I appreciate that, pushing back on the binary, there being like things that are definitely good and there are things that are definitely bad. And I think both that data collection practices are much more nuanced, and we're not going to come up with like some perfect data practice or things that are in every circumstance always going to be bad. And I also think that sometimes there's so much focus on collecting identity information when that's not actually necessarily the thing that we want to measure. Like in this instance, in the example that Scott gave us, maybe what we want to be measuring is something about gender and racial equity at this particular conference or something. And you can maybe get some measure of that by sort of counting the identities of people who are organizers or speakers or attendees. But you're certainly not going to get a very holistic vision of the experience of equity, right? And I feel like we also should challenge ourselves in these situations to think about ways that we can measure the systems rather than measure the individuals who are interacting with the systems, at least some of the time, right? Which is a concept that I'm borrowing from Data for Black Lives. Um, but I mean, are there ways that we can look at what the conference organizers are doing, what the physical space is like, what the topics are that are discussed, what the experiences of um, inclusion, belonging, violence, exclusion, etc., are, rather than just counting how many people from particular categories showed up and calling that equity. Um, Not that that doesn't matter. I think actually in some instances we do want to count some around identities, and there's no perfect way to do it. And I am really interested in the idea of different sorts of data visualizations that could make more sort of self-describe options more workable, at least in smaller data sets. But I also want to challenge us to think more holistically when we're trying to measure something about equity.
Super helpful. Thank you. I'm going to turn it over to our first questioner, who's a student here at Colorado Law. Nick, are you there? Great.
Yep.
Hey, hi, Nick. Nick Matera, thanks so much for joining us. And by all means, let's have your question.
Well, first, thank you very much for this awesome discussion. I think it's really important that we're having panels like this. I was hoping to sort of ask, I guess this question is more directed toward Gabriel and the public policy side. We talked in this panel a lot about safeguarding these environments for online environments for individuals to explore their identity. But the double-edged sword of that those environments can fuel violence or abuse and disenfranchisement. I think Professor Skinner-Thompson, you said the burdens of inclusion are falling on those that inclusion is designed to benefit. So Gabriel, because you're operating in the legal community, I was wondering if there are public policy solutions, at least on the table, like the Equality Act, that are addressing these issues. Are policymakers ready to have that conversation, or what you were saying before is case law sort of where the ground floor needs to be established?
Well, I'm also interested in other folks' thoughts on this, especially Avatara, who's also in the law and policy world. I mean, so this is, I mean, there are a lot of different types of violence and exploitation that can happen, at least in part, online. Um, in my particular work, what I'm most aware of and concerned about is when the government or large businesses are using people's statements about who they are, who they associate with, et cetera, against them in some way, whether that's for purposes of criminalization or job discrimination or something else. And in terms of policy solutions, I mean, so the Equality Act will do more to make it illegal in more contexts to discriminate against people. There are currently gaps in federal law, particularly around public accommodations and certainly in certain federally funded services where there's really not much of any protections, and there could be. But of course, even when we have laws that are making discrimination illegal, that doesn't mean the discrimination stops. Unfortunately, it's been against the law for a long time, for example, to discriminate in employment against Black people or people with disabilities, but unfortunately that's still really common. That doesn't mean that those things are not worth doing. And I think there are actually a lot of different ways that we can do that. One of the public policy things that I think is particularly important and exciting in trans law right now is the push to decriminalize sex work, which has a lot of implications in when we're talking about digital spaces. Right now, there's a federal law that that has taken away most of the online tools that sex workers have used to find and screen clients and to sort of help each other stay safe. So I think that public policy that takes away some of the criminal penalties that right now are used against people in digital spaces is really important. Um, and I mean, there are a number of other measures that people can take, and I'm just going to be honest that I'm also not somebody who is deeply familiar with a lot of the intricacies of tech law. So I'll pass it off to my colleagues.
Yeah, I was just gonna quickly jump in. I think that conversations around safety and security, especially when it comes to digital platforms, often deny autonomy to the communities that are actually experiencing that form of violence. That's something that I like realized happening recently with regard to Clubhouse. There was like a conversation around, safety, security, and Clubhouse and users, and like people couldn't understand for the life of them why certain people would be signing up for Clubhouse. And I'm like, actually, if you think about, historically, storytelling based communities, so specifically speaking about like Black communities that are like, have a rich tradition in like, oral storytelling, whether, oral or written, whatever. I've seen like an amazing way that people have come together on Clubhouse to talk about things, especially with regard to gender and sexuality. And although we can acknowledge that there are definitely violent spaces there where, the same conversations that are going to happen outside of Clubhouse are going to happen on Clubhouse. It's been interesting to watch community navigate how to actually control that. And so, what I think about so often is that there are folks who come in saying like, oh, what's like the policy response, or what's the response of this specific entity to like this type of violence? And my question is always like, well, have you actually talked to the communities that are experiencing that violence? Because so often everyone wants to jump to like doing something in order to like police it. And what we notice that typically happens is that when we actually create policies, they tend to actually typically silence and cause more violence to the people who are impacted. And that, and sometimes they end up being the ones who are actually like removed from deplatformed, removed and silenced, and this, that, and the third. So that's the first thing that I come back to. But as to what Gabriel was talking about, my concern honestly when I think about what can happen in terms of like violence in digital spaces usually comes back to the state. And it's like, how is the state actually, surveilling, collecting, distributing this information for the benefit of their own goals that often lead to like, criminalization and all this other stuff. And I think that that's a conversation that like, I don't know, it's so interesting because I feel like that's one that people sometimes shy away from. They just rather think about like interpersonal violence as something to address. I'm like, actually, let's talk about the state, because that's actually where the issue lies. Because often in the ways that they criminalize people, that's how you see communities actually start to criminalize and police and surveil their people as well. And then there's a natural flow there.
Absolutely. Thank you both, Gabriel and Avatara. Another audience question, this one from my church colleague, Margot Kaminsky. And when Alex was talking, I immediately thought of Margot, and so was glad to see this question. Margot, Alex is interested in more in the difference between contestability versus contestation, and put differently, what is the difference and the different values of allowing contestation, in the boardroom or in the design room, so to speak, versus allowing people to contest their own identities as as generated or portrayed by tech communities. And do you think both approaches are necessary, or what are the limitations of these different approaches?
Yeah, I appreciate that question, Margot, and thank you. I mean, I think I want to step back and sort of situate this, because there's sort of like kind of the broader conversation. And we just finished this conference this week, which is kind of the big conference in, I don't know what you call this field, AI ethics, fairness, accountability, and transparency. And I think the kind of where this often lands is thinking about these kinds of concepts in kind of in the hands of particular sorts of people who are building these systems. So what does like fairness mean? What does accountability? How do you build that in? Transparency, how do you actually make this transparent? Explainability is another one. And there's a decent amount of academic work that's on looking at, what does this mean? What does it mean to actually have something that's explainable? On the facial recognition front, what does it actually point to? And there's sort of certain kind of technical aspects to this where, some of these methods will highlight parts of the face or something that highlight it. So I think it's important to understand, like, when framing this idea of like contestability, thinking about who is able to contest it. Maybe a better kind of analog is that's kind of a related concept is more of the idea of recourse, which I think has a much more kind of understanding, or at least kind of legal definition. So recourse, for instance, if there's, the oh gosh, what is it? The Fair Credit Reporting Act allows you to actually have some kind of recourse, have some kind of explaining of where credit's for. And it's probably one of the only sorts of ways where we've seen that kind of policy been translated into kind of things like, now you have a right to actually make some kind of claim of sort of like, what does it mean? What would I have to do to actually change my credit score that would actually increase it? And that gets divided up. This is a lot more vague in the area of, say, computer vision, like where you're saying, well, what would it take to actually, how do I need to change my face to actually have some kind of decision that would not, that's of course not actionable. And so people, and that of course extends to areas of race and gender and whatnot. And so, like, that's, I guess, where the boundaries around contestability lie. I think especially if you're talking about contestability as being designed into a system and allowing users or people to actually kind of contest various outcomes. I mean, I think there's benefits to the idea of it, in a way that I think goes beyond the idea of saying just transparency, which just kind of opens up the black box. But there's also, some limitations to it. And I think, that's sort of, there's different sorts of policy implications, I think, that stem from that too. And I'll drop the kind of the paper by Mulligan et al. Into the chat as well.
I just want to add on that quickly too. I know to draw this distinction, I think is a theme that runs through a number of comments from the past hours. We need to not conflate self-responsibilization and self-determination as possible ends, right? And so we might have we might make certain kinds of contestability possible, but there's still ultimately sort of your well-being and your opportunities for thriving are still contingent on your ability to contest within the terms sort of presented to you by a dominant policy or structure or order. And how are we supporting modes of life, ways of being, ways of organizing communities, weaving communities that don't exist as like a sub pocket under that framework, but that can thrive and exist alongside and independent and outside of particular regimes. And so I just want to draw that, like that's what I see as like the distinction between self-responsibilization and self-determination is like, to what degree is your ability to contest and to sort of perform and express certain identities sort of contingent on a set of terms given to you versus your ability to do that independent of those terms. And And I think that's a key distinction for us to hold on to.
Thanks, Anna. One last question, which I think is, I've seen some nice parallels between, the different structures we're talking about, whether it be the carceral state or, tech capitalists. But one question from the audience deals with, I think question of inclusion on the bench, inspired by Gabriel's example of the trans person's existence being deemed in effect probable cause and criminal. The questioner asks, is that more attributable to the structures or to individual bias on behalf of the judges, or taking Anna's cue and resisting these false dichotomies, all of the above. And I just, I mean, and I'm interested in everybody's responses, but it is interesting. I mean, I just learned yesterday that, for example, I think President Obama or President Biden just nominated the first Muslim person to the federal bench, which is obviously significant, but that's not going to solve much, but it is no doubt of value. And so maybe that example underscores the tension in the question too.
Yeah, I mean, I definitely think both end. I think also, Andrea Ritchie and others have done, Jessica Pliley, like there are a number of people who've done work on how policing in the United States it's always been racial and it's always been gendered, right? And those two things have always been together. There was never a time when policing and law enforcement, at least since European conquest, where it has not been about policing gender and sexuality and race. So I think because of individual bias, because of the laws themselves, because of cultural bias, I think all of these things have mutually reinforced each other and are still very much present in a way that people don't always recognize. The laws themselves, some of them specifically name gender, many of them do not, but that doesn't mean that they're not about gender, right? It doesn't mean that they weren't created partly for a gendered purpose. It doesn't mean they're not enforced in gendered ways and interpreted in gendered ways. I do think that who's on the bench matters. It makes a big difference. You can tell just because, Avatara, you can probably speak to this too, but as soon as we get a judge assignment in one of our cases, we're like, all right, either we're golden or it's all over already. Doesn't matter what we do, we've just lost, or something in between, right? So it makes a huge, huge difference who it is, but not just in terms of the identities they hold, but also in the ways that they interpret the law and their concept of what justice means, right? I would love, right now, we've never, as far as I know, had an openly trans person on the federal bench. It would be great if we had that. It would be great if we had a lot of trans people of color. It would be great if we had a Supreme Court that was majority trans people of color. Even if we had that, it wouldn't actually solve all the problems, right? It's so baked into the system in so many different ways that I don't think representation alone will be enough. But I do think that it would be great to have some better representation on the bench.
Well, great. Thank you so much. I wish that, you could hear the thunderous applause I know you would receive for this tremendous conversation. You all are luminaries, and I really appreciate you taking the time out of your busy and in-demand schedules to share your wisdom and grace with us. And so thank you so much, Alex, Avatara, Anna, and Gabriel, for the important work that you're doing, making our world a more just place. And I look forward to continuing to be the beneficiary of all of your efforts. So thank you. And with that, we'll close out this second panel, and we're going to move right to our keynote address before taking a longer break at lunch. So don't go anywhere. I'm going to introduce you to our keynote speaker at this time. So for those of us that are just joining us, welcome to the Silicon Flatirons annual privacy conference this year, focused on privacy at the margins. We've had a simply fantastic morning, and it just keeps getting better and better. And it's my real joy and honor to introduce today's keynote speaker, Dr. Anita Allen. Dr. Allen is the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania, and she served as Vice Provost at that institution for 7 years. Dr. Allen's a graduate of Harvard Law School, receiving her PhD in philosophy from the University of Michigan. She is a global thought leader in the fields of privacy law, data protection, in ethics. Her scholarship is foundational in the area of privacy and discrimination. Among her numerous publications include several books, including Unpopular Privacy, What We Must Hide, The New Ethics, a guided tour of the 21st century moral landscape, and why privacy isn't everything. She is widely cited, has visited schools across the globe, and we are extremely lucky to have her as our keynote speaker tonight. For me, this is a real honor. Ever since I was first started in academia and started thinking about privacy, Dr. Allen's books were some of the first I read, and I've gotten to meet her in passing at a couple privacy conferences, but I was so thrilled when she accepted this invitation. So Dr. Allen, thank you for taking the time to share your thoughts on privacy through an African American lens. Dr. Allen's going to talk for about 30 minutes, and then we will have 15 minutes of question and answer. So with that, Dr. Allen, thank you for joining us.
Thank you so much for inviting me. This is such an honor. As you can hear, those of you who don't know me, I've been around for a long time. If you can think about someone who started college in 1970, you can kind of guess my age. But it's been fascinating to watch this field grow and develop. And I'm jealous of the younger folks, but for one reason, and that's because I would have loved to have had brilliant allies like the folks that we just heard on the previous panel to join me in my early efforts to sort of slog through the concept of privacy as it applies to the law. So I'm going to use some slides today, and let me just make sure I can screen share and I can get right started. Let's see, there we go. All right, I think we're right here. Okay, thank you. So I am a lawyer, as was just mentioned. I'm also an academic philosopher, and my special interest is in the ethical and legal dimensions of privacy and data protection. since the 1980s, I've been interested in the privacy of marginalized populations. So I'm thrilled, of course, by this conference and by the work of Scott Skinner-Thompson and his important book, Privacy at the Margins, which had a huge impact on sort of propelling me to make this one of my primary concerns. So thank you, Scott, for your leadership. In my very first book, and this is one that Scott didn't mention, Uneasy Access, Privacy for Women in a Free Society, I included chapters about how lawyers and philosophers define privacy and how it has value and why it matters practically and politically. I focused at that time on the rights of women and the feminist critique of privacy with the feminist critique of privacy sort of as my focal point and insight. And I wasn't just focused on the privacy of middle-class white women, but also on the privacy of women of color and poor women as it relates to issues like birth control and abortion, also freedom from sexual harassment, and the privacy rights of sex workers. In the early 1990s, I started to think more about the history of privacy law. And I wrote an article called How Privacy Got Its Gender, about the role that concerns about women's modesty and our privacy played in shaping the development and growth of American privacy law. And that role was huge. If I'm not mistaken, I may have been the first person to really analyze the issues of gender embedded in the famous Warren and Brandeis right to privacy article from 1890. So after I wrote that article, I also began to focus on the rights of women of color who were being asked to serve as surrogate mothers and surrogate gestators back in the 1980s and early 1990s. And then the internet happened and the web and social media. So in response to these newer concerns, I shifted my focus. I wrote an article called Women and Privacy in Cyberspace, arguing that women are vulnerable to privacy invasions in cyberspace, quite analogous to those that they experience in the non-digital world. Something I'm sure is also true of LGBT persons. So never really forgetting, though, the offline world, I've written about the usefulness of the privacy tort for LGBTQ plaintiffs and why HIPAA doesn't necessarily entail robust medical privacy rights for women. Well, something big happened in the world last summer that changed the focus of my work. So last summer, the protests and riots that broke out across the country were truly upsetting. And the George Floyd murder, broad daylight by a Minnesota police officer who pressed his knee into Floyd's neck until Floyd stopped breathing. The officer claimed that he was just doing what the US Constitutional Bill of Rights allows him to do, which is to seize a criminal suspect. Breonna Taylor, an innocent Black woman, was shot by the police who burst into her apartment late at night looking for evidence of drug crimes by her ex-boyfriend. Well, I realized that after these upsetting incidents that I hadn't spent sufficient time looking at privacy through the lens of race and the intersectionality between race and gender as it relates to privacy. There were a couple of exceptions that I could give myself as I was scolding myself. One exception was that I did write a chapter on racial privacy in my book, Unwanted Privacy. And in that chapter, I did about the idea that we really don't want to, we love the Europeans, we love the EU Privacy Directive and the GDPR, and we think that they're superior regimes in many respects to our law. But there's one respect in which I think we shouldn't copy the Europeans, and that is in treating race as a sensitive category and denying folks the ability to use race for remedial purposes. So I wrote about that. And then in my book, Why Privacy Isn't Everything, which thank you, Scott, for mentioning, I talked about accountability. And everybody likes to think that privacy is everything, but of course it isn't. We are accountable to other people. And in particular, I suggest we're accountable to people of our own race and ethnic groups, and sort of point out some of the social norms that suggest a kind of cultural accountability that does go along with racial groups and ethnic groups as such. So this afternoon, in the little time that I have, I'd like to share with you some examples of what I'm seeing and increasingly thinking about as I look at privacy through the lens of my race and my gender. I'm led to propose a different way, a bottoms-up way of thinking about the task of defining what privacy means that I call this approach critical definitional facilitation. And the top-down approach that I reject, I'm going to describe as definitional prescription. These techniques, these methodologies have served as barriers actually to people with backgrounds in philosophy like me, getting beyond the ivory tower into the world to make the world better. We need to stop focusing so much on analytic definition of the word privacy and more on doing justice for marginalized peoples. So we're living in a digital age, of course, and we're all concerned about the weaponization of technology. We're worrying that our society has become a benthamite panopticon, and even worse, what's being called the banopticon, in which the legitimate interests of marginalized groups are forced out of the sightlines of civil society. Privacy can mean power, as illuminated by Carissa Velez. It can also mean the lack of power and powerlessness. Technology can be a benefit to women of color and women of all backgrounds and people of color, but it can also be a problem. But in terms of it being a benefit, many have pointed out that technology has enabled greater solidarity and greater ability to watch the watchers and greater ability for us to deter and to document some atrocities. But again, technology can be and often is a tool of domination. So today, looking at privacy through the lens of race, there's so much to consider, and this conference has brought out some of these points very, very well, and will continue to do so. But let me just give you my summary of what I think we're all thinking about as we think about privacy through the lenses of race, gender, LGBTQ, trans, poverty, etc. So the extent to which privacy is a commodity more available to the wealthy and privileged classes, that's one concern. Another is whether race should be considered private and sensitive as it is in the EU. How people dependent upon government benefits and programs are required to sacrifice privacy and private choice. How mass incarceration has meant lives without privacy or the wrong kinds of privacy, meaning isolation in solitary confinement and supermax confinement. How the affordability of privacy protecting technology impacts the distribution of data privacy. How big data analytics rely on algorithms potentially unfair to minority races. And finally, how surveillance technologies, including social tracking, street cameras, body cameras, facial recognition, spy planes, unfairly target minority populations, undermining freedom. So quite a huge agenda when we began to look at privacy through the lens of race. But when you look at privacy through the lens of race and female gender, what one sees are stories of both victimization, but also of agency. And I think we need to talk more about the agency side of all of this. So looking at privacy through the lens of race and gender in an American context is an opportunity to celebrate the ways in which Black lawyers, Black NGOs, and ordinary Black men and women facing unjust prosecution have led to landmark legal rulings that benefit everybody. So Thurgood Marshall and the NAACP brought the landmark case NAACP versus Alabama, in which the US Supreme Court found that the First Amendment protects associational privacy. Tyrone Garner, one of the petitioners in Lawrence versus Texas, was a Black man, and that case decriminalized gay sex in the name of 14th Amendment, equal protection and privacy. Shown on the slide, a humble Black and Native American woman illegally married to a white man was behind Loving versus Virginia, the case that decriminalized interracial marriage and set the stage for the decriminalization and the illegality of, and the legalization, excuse me, of gay marriage, same-sex marriage. So I could go on, but clearly these are examples where brave men and women launched legal battles that resulted in additional privacy, not just for them personally, but for everybody and for people of all backgrounds and races. On the other side, many of our famous criminal procedure cases involve Black petitioners that in effect serve the role of helping to create more restrictions on police power and benefit lots of people, including people of color. So Dalry Mapp was the petitioner behind the Mapp versus Ohio case. That was the case that led to the exclusionary rule that evidence acquired in violation of the Constitution is inadmissible in a criminal prosecution. So we have our heroes. We also have our scholarly heroes and heroines of color, from Oscar Gandy, who wrote an important book called Panoptic Sort decades ago, to Simone Brown, who wrote the wonderful book Dark Matters. So Simone Brown's work is very arresting. And from her, I actually learned, I'm a philosopher, but I learned from her that the British philosopher Jeremy Bentham wrote the Panopticon letters describing methods of efficient observation and control of persons in confinement while he was on a ship with a cargo of Black women slaves, Black women enslaved persons. As suggested by 20th century judge, by a particular 20th century judge who started the legal right to privacy as a positive law matter in the United States, privacy deprivation is a kind of slavery. And I think that it was very telling to me that Simone Brown tried to link the concerns of our surveillance society with slavery. And I'm doing the same thing with you today. I'm linking the normative, the philosophical values of privacy with our opposition to the horrors of chattel slavery. So in 1905, you privacy scholars know this, Patches versus New England Life Insurance Company became the first American state court case to find that there's a legal right to privacy in common law. This opinion was based in part on the work of Warren and Brandeis, who argued for a right to privacy that was a right to, quote, be left alone. So Warren and Brandeis, they spoke from a throne of privilege, and they talked about inviolate personality and man's spiritual nature. But the Patches case talked about slavery. So if you look at the opinion that Judge Cobb wrote, he despite the fact that Judge Cobb was the son of slaves, the grandson of slaves, the nephew of slaves, the nephew of the man who wrote the Confederate Constitution, he understood that privacy invasions, even ones like the one in the slide showing the man, Mr. Pavsich, who woke up one morning and found his photograph used in an ad for insurance in an Atlanta Constitution newspaper and brought lawsuit. Even that kind of violation has an affinity to slavery, because so in the words of the judge, the knowledge that your features and your form are being used and displayed brings not only a person of extremely sensitive nature, but even the individual of ordinary sensibility to the realization that his liberty has been taken away from him, and that as long as the advertiser uses him, and I underscore the word uses him for these purposes, he cannot be otherwise than conscious of the fact that he is, for the time being, under the control of another, that he's no longer free, and that he is in reality a slave without hope of freedom, held to the service by a merciless master. Now, years ago when I read this case for the first time, it almost offended me that the judge would analogize having your picture used in an advertisement with chattel slavery, the horrors of which are shown here on the slide. The picture of Gordon, the enslaved man who ran away with the scars of physical abuse that became such a famous a photograph and a famous sort of cry for the end of slavery and similar institutions. But there is a connection. I just want to draw that out a little bit today. So in the meantime, though, we find that in the world of tech talk and in the world of privacy talk and discourse today, that many people, whether they're tech innovators or government and officials or revenge pornographers, they like to silence privacy discourse by claiming that people are consensually giving up their data. I had permission to post those images of my ex-lover on the internet, or she gave me or they consented to terms of service, and so my using their data is not a violation of their privacy rights. But that kind of consent talk should not intimidate us, because we know that the discourse of consent was actually used to defend slavery itself. There were many philosophers who in the 17th, 18th, and 19th century wrote about slavery, argued that from a sort of social contractarian point of view, that slavery was the best deal that inferior Africans could expect to get. They were lucky to be able to be rescued from their savagery, and they in effect consent to the superior domination of white races. So we shouldn't let consent talk, even today, cause us to think that we have a reason to be shut up and to stop talking about privacy. And And then there are also people, especially in philosophy, who claim that the term privacy is confused, ambiguous, vague, marginal, obscure, unnecessary, overbroad, non-paradigmatic, elusive, nonsensical, unclear, contradictory, and meaningless. And they suggest we should use other terms instead. Again, trying to deprive people for whom privacy is a powerful discourse from using the discourse. And so a very popular strategy is to claim that privacy is intractably vague, and therefore we can't use it in trying to develop policies, especially in the digital age. Concepts like de-identification, and as well as the no privacy in public idea, are similarly used as ways to try to deprive people conceptually of the ability to use privacy discourse. And this is something which we must fight, and that I, as a philosopher, am particularly concerned about trying to fight. And you know, again, the whole slavery analogy point to me is consistent with the strong privacy message of Shoshana Zuboff in The Age of Surveillance Capitalism, where she talks about the ways in which we're losing control over data, and it all has to do with the foundations of capitalist thought and practice. But in her recent New York Times article, she made a very interesting point about how there is actually a knowledge coup going on. She saw, as we all did, the January 6th coup attempt on our federal government, on our Congress, and she said, well, there's another coup going on that we're not paying as much attention to, and that's the knowledge coup, represented by the ways in which we're allowing and our privacy, our information to be taken away, that technology is using us, and we're using it, but it's using us in ways that quite literally threaten to seize our democracy. So I think that we need to start to think about privacy, that the history of privacy and the growth of privacy law and privacy law itself in a different way. To not start with the Warren and Brandeis story about cameras and newspapers and tabloid journalism, but to instead start with the image of slavery. So I'm starting to tell the story of privacy now by beginning with the story of Lydia, a case called State versus Man from the early 19th century, the 1820s. This is a case brought by a petitioner who was a white man who believed he'd been unjustly convicted of having shot and wounded an enslaved woman. But Lydia was the hero here. She was attempting to run away from a man who was beating her. She'd been hired out to this guy. He was beating her unjustly, she felt, and she tried to escape. He shot and wounded her. The white community didn't think he should have shot her. They made sure he got prosecuted, but the North Carolina Supreme Court overturned his conviction. And he did so using the language of privacy, arguing that to prosecute the white man for shooting the enslaved woman would be to undermine the privacy of the slave-master relationship. And that same Supreme Court in North Carolina, a couple of decades later, used similar reasoning to justify not prosecuting a white man who had beaten his woman. State versus Rhodes. Mrs. Rhodes brought a suit against her husband for assault, but the court said we can't interfere with the privacy of marriage, the privacy of the domestic life. And so we saw, as a beginning, privacy discourse being used against marginalized peoples, which we must never forget. But at the same time, we must remember that the point that we were attempting to make, that was attempted to being made long ago, is that marginalized people do have important rights. And among them today, ironically, is the very right to privacy that their masters and their husbands had and wielded against them in the 19th century. So continuing the story of privacy law, right? We all know the story of Rochester versus Folding Box Company and the beautiful young woman whose picture was on a box of flour. Roberson versus Rochester Folding Box Company. Excuse me, I think I misstated the case name. Roberson versus Rochester Folding Box Company. Beautiful young white woman. Her picture used without her consent on a box of flour led to a big flap that led to us to have the famous New York civil rights laws that protect people from having their images, their names and likenesses and identities appropriated for commercial purposes, or or trade purposes in New York. So that law stands. But what scholar Eden Osuka has pointed out is that about the same time, and even before Roberson, there were many dark-skinned, obese Black women being used by the Aunt Jemima pancake flour company to advertise pancake mix, and nobody was alleging that there was something unseemly, improper, immodest, or private about the Black woman's image that should cause reluctance to put her out there selling pancake flours at expositions, fairs, and also having her picture on the box. There's a whole stream of Black women who played the Aunt Jemima role, including the first one who had been a former enslaved person. So, we're working on sort of two fronts here. One is trying to retell the history of privacy in a way that foregrounds the struggles of marginalized people to be heard, right? To get attention, to be heard. And I'm emphasizing here again, African Americans, the women, but one can emphasize other groups that have been similarly left out. And then the second front we're operating on here in my talk is trying to deal with the fact that philosophers have, I think, let us down, and they fussed over the definition of privacy at the expense of turning their attention to the real problems in the world suffered by people of color who would like to use the privacy discourse, but who are being told that their concerns about things like, again, like about arrests or marriage rights or abortion rights. Those aren't privacy concerns at all. So I was very happy to see a couple of years ago when the Indian Supreme Court in the Puttaswamy decision, Puttaswamy versus Union of India case, that case was the landmark case that created the right to privacy in India for the first time. And the right not only opened the door to more restrictions on biometric identification-based ID card in India, but then 1 year later, that same decision was used to decriminalize gay sex across the nation of India. And I was pleased that the court acknowledged all these philosophical debates by lawyers and philosophers over what privacy means, but they didn't stop to fuss over those definitions or to view their job as harder because people don't agree about how to define the word privacy. They just got the job done. They got the job of putting restrictions on a biometric ID card, and they got the job done, essentially, of also opening the door to more freedoms for LGBT people in the nation of India, one of the most populous countries, of course, in the world. So what I think the problem has been on the philosophical level is exemplified by this slide. If you read the bottom of the slide, this is how a typical analytic philosopher talks about privacy. So you have someone like William Parent saying that he proposes it to define privacy as ... and he goes on to give a definition of privacy. And the definition he gives as undocumented personal information, being had by others. It's like, your eyes glaze over as you think about Trayvon Martin or George Floyd. How do we get from the ivory tower task of defining the necessary and sufficient conditions of using the word privacy, a prescriptive definitional and that analytic problem, to addressing the urgent problems faced by marginalized people? How do we get there? Well, I have a thought about how we get there. I would propose that our approach be instead one that I call critical definitional facilitation. And here we don't start with prescriptive definitions of privacy like the one we saw on the last slide by William Parent. Instead, we assume that privacy discourse belongs anywhere there's an assault on or a diminution of the person that threatens to use us, to use people or treat people as if they were slaves. And that we attack problems after we've identified them, and that we define privacy pragmatically as we go along, as we need to. If in order to get a legal matter involving a Trayvon Martin or a Breonna Taylor or another person before a court, we need to have some definition of privacy. Let's just stipulate one that can kind of get us through the door and we get the job done, not to be to be confined by or constrained by the need to find a definition. And philosophers often act as if somehow courts can't operate unless they have a precise definition of privacy. That's not true of privacy. It's not true of the word equality. It's not true of the word solidarity. It's not true of the word liberty. But for some reason, a lot of people think that somehow we have to define privacy before we can move forward with an affirmative progressive agenda. We don't. So, you know, I think that the work of Kiera Bridges has been very important in terms of helping us to see that there can be a poverty of privacy rights if, in fact, they're not privacy rights are not utilized in the right way to help people who are dependent, especially upon government services, et cetera. But privacy rights don't have to be impoverished; they can be quite strong, and we can not yield to the notion that somehow if we're stuck with thin negative liberties and that's all we've got. I think we need to think about ways to continue to rehabilitate privacy discourse and to use it, because it is a powerful discourse, and people do often feel as if the main thing that's wrong in their lives is that they don't have enough privacy and private choice. The problem of facial recognition is just one of the great example of what's going on today. The ways in which people feel that their privacy and their liberty is assaulted by these technologies that don't work that well. Najir Park spent 10 days in jail, 10 days after being misidentified by New Jersey police using facial recognition technology. He was accused of having stolen some candy from a hotel and having crashed into a police car. Guess what? He'd never been to the town where the theft occurred, Woodbridge. He didn't own a car. He didn't own a driver's license. He had an airtight alibi. He still spent 10 days in jail, despite things like fingerprinting that might have proven that he wasn't the person that they were actually looking for. We've seen from the brilliant work of Joy Buolamwini at MIT that facial recognition technology is very bad at discerning skin color, discerning one person of dark skin color from another person of dark skin color. It's also very bad at discerning dark skinned people's genders. If we're just in kind of a binary world of male, female, well, this technology she's shown is very bad at discerning male versus female faces when the males and females are dark skinned. There's something like a 34% error rate versus a 1% error rate for people with lighter complexions. Yet this technology is being weaponized against Black people all the time. Thank you for what's happening in Oregon and some similar jurisdictions. It's being used less often or not at all. So rather than like marginalize the concerns of women of color and people of color generally, the philosophy of privacy should, as I said before, begin with the story of the ways in which privacy discourse was used at the beginning of our country and move up to ways in which the discourse of privacy has been adopted and by minority cultures and used by people of color to do good work, as it was, in the 1950s by Thurgood Marshall, as it was in the Roe versus Wade context, as it was in the context of our getting greater rights for LGBT sex and same-sex marriage. There are some, examples I could give of abuses of Black folks' privacy, with Black women's privacy that do strain what we mean by privacy. But I think you could sort of see the Henrietta Lacks story, which is a story of the woman who, whose DNA, whose cells from her cervical cancer were used in research for many years before her family found out. Basically, she had a very bad case of cervical cancer. In her surgery, some of her cells were sent to a scientist working on trying to preserve the life of cells in the lab. He found that her cells were incredibly reproductively magical. They would be produced again and again and again. So her cells had a kind of immortal life, hence the name of the book by Rebecca Sloot. But in the event, her bodily integrity and in some ways her privacy in the sense of the right to choose, the right to have informed consent was violated, as was that arguably of her family after her death. Again, we're sort of using the discourse of privacy here in ways which some philosophers would say it's confusing, vague, etc. But again, if you foreground the problem and not the definition of the term, we can get the work done. Right. And so her family's been fully compensated for the wrong done to her, which is a good thing. Thank you, Johns Hopkins. Another point I want to make briefly here is about the ways in which even when we have strong privacy laws, they don't work the same for people of color, for women of color in particular, and women. So these are two examples I could give. We have Dr. Nikita Levy, who is a OBGYN affiliated with Johns Hopkins. For years, he saw patients, around 8,000 different women, and he had these little spy cameras and spy pins in his office, and he was basically videotaping or videoing his encounters with women. So their breasts, their genitalia, their examinations, their conversations were recorded, and he was serving all this stuff up on a bank of computers he had in his home to the internet. When he was finally detected, he was so ashamed of himself, he actually committed suicide. The women who were affected eventually got settlements from Johns Hopkins, ranging from a couple of tens of thousands of dollars to over $1 million each. Then we have the scandalous case of Dr. Larry Nassar. He, like Dr. Levy, lived in a HIPAA world. We have this federal statute, the Health Insurance Affordability and Accountability Act. It has privacy and data security regulations attached to it. But those kinds of laws don't work to protect women if the healthcare providers simply do not respect women. And so Nassar didn't respect the young women that he was treating, and Levy didn't respect the young women and older women and women of color that he was treating in his practice in Baltimore. Another sort of weakness of privacy law for people of color can be shown in the case of Chantelle Jackson. She was the girlfriend of a prize fighter, Floyd Mayweather, who posted online intimacies about their life, including an image of an ultrasound of twin fetuses that he claims were aborted. But her privacy claims in court were not very well treated. The judge threw out all of her privacy claims, except for one relating to the ultrasound. But her own privacy claims about her cosmetic surgery images being put out there on the internet by her disgruntled ex-boyfriend, the court just threw those out, claiming that, well, people like her, celebrities, they're on the internet all the time, they live for social media, they don't have any privacy rights worth protecting. And then finally, I think that we should talk a lot more than we do in the privacy world about sex workers, as was mentioned in the previous panel. A lot of times the sex workers' rights are defended under the banner of personal autonomy and privacy. While that liberal dream is questioned and criticized, it's a very real consideration as to whether or not the decriminalization movement or the lack of it violates women's privacy and personal autonomy, and sex workers who are men, their privacy and sexual autonomy too. And in terms of marginalized people, I'll just note here that France, when it introduced a new law recently, it estimated that 90% of the country's sex workers were victims of Nigerian, Chinese, or Romanian trafficking networks. Again, talking about autonomy and privacy here, where privacy has a very complicated and nuanced set of meanings. So I've gone on a bit too far, but basically, I think that we should define privacy by reference, first of all, to the problems we want to solve, and that we should understand that basically the mandate to do justice through privacy discourse is all about the values that I have on the slide, including agency, power, non-exploitation, autonomy, homes and families of one's own, if that's what one wants, limited government, and in the final analysis, justice. So I will shut up there, and we have time for a few questions. And thank you, Scott Skinner-Thompson, for giving me what I think was a little bit extra time there, but thank you so much.
No, of course. Thank you so much, Dr. Allen. That was absolutely breathtaking. And you're just, yeah, I mean, so many great points, but the emphasis on starting with what we can learn from marginalized community about why privacy matters, and it matters because it's visceral, and you painted such a vivid picture of that was incredible. So thank you for concretizing privacy harms. To get us started in terms of questions, we have a student here at Colorado Law School, Lily Wasser, who's going to ask our first question. Go ahead, Lily.
Hi, Dr. Allen.
Hi, Lily.
Thank you so much for your presentation. I just wanted to kind of ask a little bit that one of the earlier panels on racial and immigrant discrimination was talking a lot about how there's kind of a lack of understanding and literacy among a lot of these communities who are affected. So how do we take this kind of broader philosophical conception and break it down so that you also talked about identifying when we cross those privacy lines in these communities and using those to kind of create new cases and move privacy forward for these communities. So how do we cross that boundary between literacy and understanding privacy and understanding how privacy is being invaded in order to bring this forward?
Yeah, so there's a lot of education that needs to go on. I think that lawyers like ourselves need to be educated about the communities whose privacy and related rights are being compromised, so that we can help them. And once we identify populations that we think we want to help, if we feel that the population needs more information, we can try to give it to them. It's interesting about how educating people might affect their interest in having their privacy rights protected or not. There's a very interesting study that I read about a project where they want to know how people's understanding of their privacy rights might affect their willingness to serve in human subject research. To targeting low-income minority women, they asked them about their willingness to participate in the study. There was a control group that was right away told about HIPAA and about their privacy rights, and a group that was not educated about HIPAA and their privacy rights right away. The group that was educated about their privacy rights, they were more likely to decline participation in the research than the group that didn't get the information. You might think the opposite. Oh, well, if people knew their HIPAA rights, their privacy rights, they would be more willing to participate. But the opposite was true. And so I think that there's this. Not only do we need to be educating, figure out ways, and I'm not answering your question probably the way you hoped I would, but ways to address the problem that you identify, which is informing people about the rights that they do and don't have, and also eliciting from them what their privacy values are, because we don't want to impose, our bourgeois liberal privacy values on populations that don't share quite those same values. I mean, there are some variations, right? But the thing that I want to emphasize in response to your question is that yes, we do have an obligation to try to educate. That might mean that we're surprised, right? And what do you do when you're surprised? How do you show respect for marginalized populations when they don't respond to privacy information exactly as you would like them to, or you would hope they would, right? That's a reality we have to learn how to deal with. I thank you for your great question.
Thank you.
Thanks to you both. Another question from an audience member about how we got here. Like, why is it that we have sort of slogged through with these prescriptive definitions of privacy for so long? Do you think that is just why do you think we've sort of had to go through that? And do you think that this is unique to the context of privacy, or do you think that other areas of law are similarly burdened by abstract notions of our different constitutional, with a lowercase c, values?
Well, there's an interesting question as to what contribution the discipline of philosophy, as compared to history or literature or economics or political science, what can philosophy offer the world, right? And oftentimes philosophers self-define as the armchair critic who simply take information and try to clarify and analyze what's going on in the world without any sense of outreach or impact of their work. So one of the things which I've tried to do as an applied philosopher is to cause philosophers to understand that they can and should do more by way of trying to positively impact the world, to get out of the armchair and to not prioritize the analytic methodology that they do in such a way that then they do nothing else. They just years and years and years of analyzed necessary and sufficient conditions for something to be an example of something else. A lot of it has to do with the dominance of Oxford, Cambridge style analytic philosophy, which took a grip on the United States in the 1970s. It was the way to do philosophy. It wasn't a practical discipline. So people like me who have bridged philosophy and law are the ones, I think, who are most likely to say, yeah, it's important to have conceptual clarity, but people are dying. People are literally dying out there because their Fourth Amendment privacy rights are not being respected. People are dying out there because their right to abortion and birth control are not being respected. And you're saying that those aren't privacy matters? Why aren't you instead trying to get the law changed under a privacy rubric or under some other rubric? But it's really a problem, Scott, I think of how a discipline defines itself, and a philosophy traditionally being too comfortable, being simply an armchair, ivory tower enterprise.
Thank you for that. And the last question, another interesting one, asking about whether you could engage with Shoshana Zuboff's argument about how there's this extraction, right? Of data is occurring. Everybody's impacted by that, right? It's not just marginalized groups, and so do you think that that widespread surveillance of all aspects of society changes your analysis or not, and why?
Well, everybody is having their data compromised, not just marginalized people, absolutely. But there needs to be strong voices for focusing on the ways in which the problems that everybody is facing also impact people of color, and often impact them in worse ways than other groups might be impacted. So it's that margin of difference, right? That we need to be focusing on. So for example, when Baltimore decided to use spy planes to fly over the city in order to deter or detect crime, they deliberately focused on the minority communities. They could have flown over they could have focused on any neighborhoods in their spy plane. So the spy plane, in theory, impacted everybody in Baltimore, but the authorities chose to target the planes spying on certain marginalized communities on the assumption that that's where the crime that needed to be addressed was going to be found. That's the difference, right? So everybody's affected, but then some people are affected more, right? So doctors can have spy pins in their camera, but which patients are most likely to have their vaginas and their breasts photo? Well, it's going to be the doctor who doesn't respect women. It's because we're women, and poor women oftentimes, that we're seen as easy targets. Oh, they'll never catch me because my victim is a woman. And the same thing happens with sex workers. So everybody can experience problems of sexual violence, but some communities, the trans male community, the trans female community, sex workers in general, are more impacted than everybody. So that's where I think we need to focus. And I don't think that that's inconsistent with Shoshana's work, but I think that we shouldn't let the problems of the margins get swallowed up by the center. But I think it's one of your messages too, Scott, right? The center shouldn't swallow up the problems of the margin, which are similar but also different.
That's right. No, and that's beautifully, characteristically beautifully put. And Dr. Allen, thank you so much, not just for joining us today, but for your insightful work you presented today, but your legacy of work on this topic as well. So appreciate it, and look forward to future engagements as well. Folks, we're going to take a bit of a break, allow people to take care of some concrete needs, get some food and lunch and water, and we will be back in 45 minutes for our last panel on the costs of privacy, surveillance of the poor, and then some what promises to be excellent closing remarks from our executive director here at Silicon Flatirons, Amy Stepanovich. So thank you all for your participation, and we'll see you back here at 1:30 Mountain Time.
Hello, everyone, and welcome back to Privacy at the Margins. I am Margot Kaminsky. I'm a professor at Colorado Law School, and I have the honor of moderating our final panel, The Costs of Privacy, Surveillance of the Poor. I wanted to begin by thanking all of our previous participants, including but certainly not limited to my esteemed colleagues, Professor Skinner-Thompson and Professor Chen. I found this morning to be absolutely wonderful and really reorienting for me in terms of how I think about privacy law. So this panel, the final panel, is going to be focusing on the impacts of both privacy law and policies and the lack thereof on people in positions of extreme poverty or even ordinary poverty. And the description of the panel runs roughly as follows. US privacy law, for those of you who spend any time with the Fourth Amendment, or really any time with any privacy torts at all, is notoriously home-centric, right? It privileges the home as one's castle, and it privileges those who are affluent enough to buy a home or to build higher walls. So homeless shelters, for example, are often privacy-starved environments, and public assistance programs, as we heard from Dr. Bridges in the first panel, have long intruded into people's lives, forcing them to trade personal information for what are often modest material benefits. So this panel will discuss how privacy and poverty intersect, addressing how socioeconomic status intersects with privacy violations by both state and non-state actors. So I have the privilege of welcoming three panelists today. In no particular order, in fact, in alphabetical order, we have Tricia Bauman, who is a senior attorney at the National Homelessness Law Center. We have Karen Levy, an assistant professor at the Department of Information Science at Cornell University, who is also an associate member of the faculty at Cornell Law School, and Dalia Ritvo, the assistant attorney general at the Colorado Attorney General's Office. So welcome to all of you, and thank you for taking the time to join me today. As with our other panels, the way we're going to structure this conversation is by directing a question to one of you initially, and you can take up to 5 to 8 minutes to respond to that if you'd like, or shorter if you prefer. And then after that, the other two panelists are welcome to add on their thoughts, either in response or in addition to what that panelist said. So we'll begin with a question directed to Tricia. So Tricia, as I mentioned in my introduction, privacy law is notoriously focused on the home as really the paradigmatic example of a private location or a sphere in which privacy is accepted and protected. So in what ways are public assistance programs, shelters, and homelessness policies privacy starved, and how does this impact people's lives on the ground?
Thank you both for the opportunity to talk about that and for that good question. First, what I would point out is that when we talk about home-centric, we probably should think of it as housing-centric because people living outside do consider their outdoor homes to be homes. Having said that, they are not extended the practical access to privacy or legal privacy protections for a number of reasons. And I think, a little bit of context is important here. Essentially, and I summarize it as privacy is a luxury that unhoused people can't afford. And there are a number of reasons for that. One, the practical, people live outside in public space when they lack access to traditional housing. So they are in the public view. There is no way to escape public eyes. The alternatives are usually congregate shelter settings, and these are temporary settings, usually offering only a single night of accommodation, and they are congregate, meaning that you do not have a private room in most instances. You are going to be on a cot or a bed next to a large number of other people. So there's no practical privacy in that setting. At the same time that people don't have any ability to shield themselves behind a door, close, their windows, there are a growing number of laws in this country that cause unhoused people to be subject to heightened police surveillance. So since 2006, the Law Center has tracked 187 cities across the country and looked at laws that target the life-sustaining activities of unhoused people when performed in public space. And these are entirely innocuous behaviors that everyone listening to my voice right now is engaged in. Things like sitting down, standing still, falling asleep, normal human behaviors that are treated as offenses, either criminal or civil offenses, when a person is performing those acts in public space. As a result of the increased policies that target those actions, people are subject to increased police surveillance and police contact, as well as, so that means, direct police contact and police surveillance. They will be monitored by patrols, but also the use of technology, often by police departments, to again monitor the location of where people are and the activities that are occurring in and around their outdoor homes. A couple of examples that come to mind are the use of drones by the city of San Diego, for example, to monitor people who are living in vehicles that fly over parking lots where people living in vehicles might park, or a new plan by the city of Miami to install surveillance cameras to monitor areas where people are camped outside, not only to watch their activities, but to catch, and this is, an official plan, to catch people who are engaged in unlawful food sharing. So, this surveillance can capture even people who are good Samaritans trying to provide needed services to people living outside. In addition to that police contact, there are other tools that are used often by law enforcement or what I call vigilante groups, enabled or emboldened by these policies that make living outside unlawful. Online groups, Nextdoor, Facebook groups that are dedicated exclusively to monitoring unhoused people's whereabouts. They will post pictures of people online, identifying information, and law enforcement often participates in these types of online platforms. There's an example in West Fernando Valley in California where law enforcement were active participants identifying unhoused people and giving information about their criminal histories or mental health histories online to perfect strangers. We know that there are other encampment maps that track where individual people are. So there's, a great deal of that type of surveillance. There aren't a lot of legal protections available, though. So that, it's not clearly established, and most courts have found that the privacy rights that are extended to all of us who live inside of traditional homes do not extend to outdoor homes, particularly when those outdoor homes are unlawfully in public space. So what that means as a practical matter is that your outdoor home can be searched or seized without the ability to resort to Fourth Amendment privacy arguments in court. I mean, it's just a lawful activity to search the outdoor home. It doesn't get much better when you go into the shelter system or into housing programs. And the reason for that, there are varied reasons for that, but I want to just focus on two things quickly. One, of course, is the lack of privacy inherent in some of those models. There just isn't enough individualized space. But also when you enter in, for some good reasons, data is collected from the individual so that you can be part of the homeless management information system, for example. So they'll take your name and private information, ask you questions about yourself. That goes into a database that is then accessible to a large number of people, and that's a cost of entry. And so there is private information that has to be given up, in addition to just a basic lack of privacy that we would all recognize. And that can also be true in housing programs. So even when somebody is in traditional housing, there are a couple of dynamics that I think make sense to flag here. One, people who are in those programs can be subject to different tests and required to provide information about themselves, their household, that are not required from other people who live in housing and may benefit from a housing subsidy. For example, somebody who has a housing voucher, is participating in a housing program, may have routine inspections of the inside of their home. They may have to take drug tests. They may have to provide information about their job searches. That type of invasion into private life, private decisions, and private space does not exist for those of us who seek a mortgage interest tax deduction, which is also a housing subsidy. And so, there's a real distinction in how people are treated, even when we're talking about the same category of things, housing subsidies. And the last dynamic that I'll end with is because people who are experiencing homelessness are, by definition, our least resourced neighbors. They're often members of marginalized groups. When they do access housing, when they find a landlord who will accept a voucher, when they are able to get into a program, there can be a lot of abuse related to privacy invasions because they don't have the type of leverage to fight back against, for example, a landlord or property manager just opening the door and walking in to see what's happening inside. As a practical matter, even if that may be a violation of the policy, the alternative to accepting it is to risk losing that housing. And so, there are a lot of abuses that take place in that vein as well that I think are important to highlight here.
Thank you so much. Karen or Dahlia, did you have additional thoughts on this? I did have a few follow-up questions, or really observations that are somewhat questions. So first, in keeping with some of the themes I've heard over the course of today, it really sounds like one of the core moves this conference is making, and that your observation makes as well, is to force us to expand our notion of what a privacy law is, or really what a privacy violating law is. Scholars often focus on things with the word privacy in the title, or on sort of historically traditional privacy regulations such as wiretap laws or eavesdropping laws, when it turns out that having a law that creates a very expansive definition of an underlying offense is in fact a privacy violating, or at least privacy violation propagating instrument, right? By making certain groups subject to increased policing, increased enforcement, increased surveillance. And what I wonder is, given that, could you zoom in a little bit for us on what laws in particular you would characterize as privacy implicating, that a traditional privacy scholar might not characterize in that way?
Sure. Well, an example would be camping bans. So camping bans are present in about 3/4 of the cities in our country. And many of those are camping bans that cover all of available public space. So there's literally no lawful place where someone who lacks indoor housing can stably live outside. Again, I'll note that the alternatives for people who don't have housing often is just outside, because the shelters provide really temporary accommodation, not only temporary in terms of you can't be there for multiple weeks or months at a time, but you can be there usually for a limited number of hours in each day. But the need to shelter oneself and or to rest exists beyond just those limited hours. Camping bans are written really broadly to include a wide variety of activities. So it can include the things that we all think about with camping, erecting a tent or some sort of temporary structure. It could also include putting down a piece of cardboard and sitting on it while awake. It can include resting on a bench with your backpack. It can include just falling asleep outside with nothing but your clothes. All of those things can be considered unlawful camping. Because it's unlawful, people who are performing those activities, and those are unavoidable survival activities, they are violating the law and can be, and often are, approached by law enforcement. And not only does that act expose them to a lack of privacy, they'll often lose their property as a result of that interaction, or even when there's not an enforcement activity, meaning no arrest, no ticket, no order to move along, they still may be subject to a really common practice, and I know this is very familiar to folks in Colorado, sweeps of homeless encampments, where again, the outdoor homes and property that people own are usually just seized, sometimes destroyed wholesale, sometimes temporarily stored, but they're still unlawful after that temporary storage period expires. As a practical matter, people often don't get their property back, even when it is stored. And that means that the structure that people use for themselves is lost, along with the privacy implications that come along with the displacement and enforcement. And that same, at the risk of making this answer too long, I'll say that laws restricting living in vehicles do much the same thing. That's the fastest growing population of unsheltered homeless people, people who move into vehicles. And we're anticipating a large wave of people moving into their vehicles as the pandemic puts so many renters at risk. Laws restricting living in vehicles are the fastest growing category of laws criminalizing homelessness. People's vehicles can be impounded with very little notice, sometimes literally just a knock on the door. You've got 15 minutes to grab what you can before the tow truck comes. And the fees for retrieving your vehicle are often totally unaffordable to unhoused people who are using those homes as shelter. And that same exposure takes place after a tow and impound of the vehicle home as well.
Thank you so much. I promise we will turn to the other panelists shortly, but I had two follow-up questions. So one was that, Professor Skinner-Thompson and I have each been interested in how one might use the First Amendment to basically provide privacy protections where privacy laws otherwise might fail. And I was curious, just as a doctrinal matter, whether there's been any success in using First Amendment doctrine to push back against some of these laws. The second question is thinking of Dr. Allen's wonderful keynote. I wonder what we think could be learned from these stories by re-centralizing an otherwise marginalized community in our discussion of privacy, what privacy is, right? What privacy harms are. So two things I hear running through the examples is that this really challenges two basic privacy paradigms in our law, one of which is that if you're in public, you have no privacy. And the other is that if you share information with others, it must be voluntary, must be consent, and therefore you have no privacy. So two related concepts.
That's right. Well, starting with the second question first, it's critical that we rethink what homelessness is in this country. There is a misguided and incorrect belief that unhoused people are outside because of poor choices that they've individually made, or because they are choosing to live outside in public space. And that is incorrect. There are a number of housing and criminal justice policies, as well as federal disinvestment in local communities that have led to the modern homelessness crisis. Those are policies that are inherently racist, which has led to a disproportionate number of unhoused people being people of color in this country. And we don't have adequate supports for other vulnerable populations. That's why we see 40% of the unhoused population being people with disabilities. So rethinking what a home is when we have a scenario where there literally is not enough housing for people who need it, and people who are attempting to recreate adequate housing for themselves outside in the spaces that are actually accessible to them, is key to any sort of development in privacy law, and also just in key to understanding how we should think about civil and human rights in this country. Regarding the legal arguments, living outside there aren't a lot of legal arguments that protect one who is living outside. In the context of First Amendment arguments, camping can be expressive conduct under the First Amendment, but sleeping in an encampment is not necessarily expressive conduct. There's a case that talks about having a kind of symbolic tent in order to express concern about homelessness, but there is no correlating right to occupy that tent and be free from punishment. So really, what I'd like to see, and where there has been some success, is expanding upon Fourth Amendment jurisprudence. What is society prepared to recognize as objectively reasonable in terms of expectations of privacy in outdoor homes, especially when people lack any other place to live. And if you're alive, you have no choice but to live. I think that's where there's, you know, the most fruit. We have seen some success under state constitutions, you know, the Fourth Amendment analogy in state constitutions. There's, you know, a great case out of Washington State, Pippin, that I think could inspire a similar litigation around the country. But we're still a very long way from protecting the basic civil and human rights of people living outside.
Thank you so much. That was a great kickoff to this panel. So turning now to Professor Levy, how do big data practices